As we all know, that the Code of Criminal Procedure and the Indian Penal Code are part of the colonial legacy that we inherited, and we seem to be perpetuating it. And it is having disastrous consequences on the freedoms that we cherish under our Constitution. And I'm going to discuss this and have a conversation about these issues with two of the leading lawyers of our country, perhaps lawyers who have rendered and participated in path-breaking judgments in this country on all aspects of the law. We have Mukul Rohatgi, who has been Additional Solicitor General, Attorney General for India, and in fact led many a battle for people of this country, for the citizens of this country. We have Dr. Singhvi, who is again, some say, a master of the way in which he argues in court. He is a doctor, incisive, always on the point. And of course, Mukul is a doctor in a far more expansive sense. He has doctored many a client and given them the appropriate medicine to get them relief. So let's start the conversation by asking you this question. Are we perpetuating the colonial era and the colonial legacy by allowing the same system of legal of what is the Code of Criminal Procedure to continue in the same fashion? What are your views on it, Mukul?
See, there is no doubt that there is some perpetuation of this system because we are still following those laws. And those laws were made at a time when the British ruled this country. There were some good aspects and some bad aspects. One thing which immediately comes to mind, the good aspect, namely that a statement made to a police officer is not admissible in evidence because they did not trust the native police and therefore they made this provision. But the colonial legacy, as you just mentioned a while ago, that you have what is called a police remand. So somebody is under control of the police in a police station or in a police headquarter or a room, whatever, under control of the police, what he has to say, he doesn't say, all that goes on. And what we need is to tune our criminal laws in accord with the basic freedoms of the Constitution. Namely Article 14, 19, freedom of speech, freedom to move around, freedom to live, freedom to work, and right to liberty, life, etc. Unfortunately, they have not been so attuned, and I have not as yet seen the new act which has come.
It's much worse.
Sorry. So my view is that there should be a task force which should look at these laws on the touchstone of these 3-4 provisions of the Constitution. And only then will be able to come out.
Let me ask you a follow-up question before I go to Dr.
Yes.
Singhvi. See, our law says that a police officer can arrest a person on suspicion. Now, suspicion is a subjective thing. So you have drastic laws like UAPA, you have drastic laws like PMLA, and you can arrest a person on suspicion and nobody can challenge it. This very process of arresting somebody on suspicion without fully investigating the matter is a very dangerous thing.
Yes, so I come back to this. If you look at those laws in the light of the constitutional freedoms, you need to tweak those laws. You tweak it in the light of the Constitution, that you don't give the power of arrest to a junior police officer who will lock you up, and tomorrow if it is found that there were no real grounds, in our courts, that there is no compensation for vexatious arrests. They, well, I thought he was guilty, I have arrested, that's the end of the matter. So you must tune it in that, and even if you have some drastic powers because of terrorism and stuff like that, give it not merely to a senior police officer. That by itself hasn't worked.
Yes,
it hasn't worked. Yeah. So you must have some checks that it must go through 2 or 3 levels of senior officers who should on the file order that yes, not 1 but 2 or 3 have seen the basic facts and we feel that an arrest is made out, unless it's a case of somebody committing a crime in your
That's different.
Before your eyes, like somebody committing a murder.
Right.
But if you have these things and you have those checks, again you look at the touchstone of the Constitution, maybe we can come up.
Kapil, actually, you raised a very important question, and I think it is far more than mere, changes. I think it either needs fundamental legislative restructuring, and along with that, I think it needs a complete change of mindset of the judiciary also. Both have contributed to a degradation and decay of the criminal system, where the constitutional values we are talking about. We've got these grand articles 21, 20, etc. in the Constitution. Now, what's the reality? Let me give you a very telling example. Take bail. Now, bail in the most serious offences everywhere in the world, you get bail. Leave aside a few categories of terrorism or child molestation, etc. You get bail. The classic and the only test for bail is that A, you have a presumption of innocence, and the presumption of innocence can be only effectuated by giving you bail, but putting you on conditions. And it is what we call the famous triple test. You will not interfere with witnesses, you will cooperate, you will not flee, and there is no flight risk. But that is actually in practice, and I'm now talking of the judiciary, turned on its head by adding a fourth test, which has no place, according to me, if you marry the principle of presumption of innocence and freedom. That is, कि हाँ भाई, इनको flight risk भी नहीं है, ये cooperate भी करेंगे, ये पेश भी होंगे, लेकिन gravity of the offence. I have for long believed that I must argue a matter where this gravity of the offence must be investigated. What is the question of gravity of offence? You're not convicting me, you're not trying me, you are giving some subjective view of a gravity of the offence. The whole point of bail is that till you convict or acquit me on the gravity of the offence, you give me bail. So the point I'm making is, assume all the three tests are in my favour. I have roots, I can't flee, I'm going to come every day to the police station. Still, bail is denied regularly on gravity.
It's the norm.
So this is turning the jurisprudence of bail on its head. Second example, this fact of creating more and more laws with skewed and special provisions for bail. I mean, Section 45 and all this of the PMLA or the UAPA is only some example. Point is, these provisions, and this is where I fault the judiciary, have to be consistently interpreted by the apex court to give us clear direction and momentum. What happens is today, this judge interprets it in the right way, but then there is some inconsistency. I speak in a different voice, so there is chaos. These provisions have to be interpreted very strictly. Many of them actually have to be interpreted on the constitutional anvil, and I would say the best example is Nikesh Tarachand Shah very, very minutely examined the constitutional validity of that 45 provision of the PMLA, which is draconian and said it's not constitutional in many ways, but yet our own courts have then held it differently. The point is, if you lean in favor of freedom, then, and otherwise you can't do it, then you have to have legislative intervention. That I don't think is going to happen easily. So at least within the interstices, you can interpret it correctly.
I was going to come to bail a little later.
Can I just add one thing,
Yes.
sir? He mentioned about gravity, cooperation. Now, I have a serious problem with the phrase cooperation. If I am an accused, I have a right of silence. That right is under the Constitution. Nobody can force me to speak. What do you mean by cooperation? Does
Cooperation means you must say what the police wants you to say.
Well, does it mean that I admit the offence? What else is cooperation?
Right.
See, I can understand cooperation in a case where somebody is accused of murder. Murder weapon is not found. So you say, yeah, tell us where the weapon is. So under section 27, it will lead to the discovery of the weapon.
That's right.
That is admissible, not a statement. I can understand.
Correct.
But in any other economic offence, so-called, you first say that we turn the innocence on its head by saying that we will believe that you are not innocent. Right. That's the first thing.
That's right.
That's the first error in these laws. The second is cooperation. Every judge writes like a mantra. You will cooperate, you will not tamper with the witnesses. Tamper, yes. But when you say you will cooperate, what does it mean?
No, it is worse, Mukul. There are judgments which say cooperation does not mean confession. Cooperation does not mean you will say what you will say.
Then
but that judgment comes, and then there is a dissonant voice after a short while.
What does it mean? Every judge says cooperation.
So it has to be consistently applied.
That's right. I mean, we're talking about bail provisions. Actually, I was wanting to take the conversation back to prior to bail, the custody by the police.
Right.
I think Bail comes later,
Yes.
custody comes first. So what are the parameters for custody is the question I started with. You went on to bail, but we'll deal with that a
Yes,
little later.
yes. Yeah.
So what are thoughts on that?
It's very important. We have stopped for many decades making a distinction, Kapil, between power of arrest and need for arrest. This is a fundamental fallacy. I have a power of arrest. I equate it to the need for arrest. Today, according to me, forget the fact that you are filling up your jails with unnecessary occupants. Forget the fact that you are doing it politically motivated in many cases. Forget the way that you are harassing. The fact of the matter is that I would say more than 90% of arrests would not be justified if you made the difference between the need for arrest and the power of arrest.
Correct.
All
So
the
what
arrests,
do you need to do to justify that need for arrest is the question.
see, there are two things.
Yeah.
Ideally, there should be a filter by legislation. You can say you will first record these, it will then go that stage. When two people have recorded, then you can arrest.
what I
That
was
is
saying,
one.
yeah.
But that's never going to happen. Unfortunately, it is not easily going to happen. Whoever is in power, you tend to go with the power. It is for the courts to start reading it like that. But again, there, consistently 5 Supreme Court judgments the same line, then the law will be laid down. You have to say that, what is the point of arrest? You are arresting people, Kapil, in most cases we are all doing, after 2 years, after 3 years. Anything you wanted to collect is there, papers have been collected, raids have been done, statements have been recorded. What is the need
But
for
you
arrest?
are also arresting people without any evidence at all.
That's the other
That's
category.
a far more serious issue, because now if you target individuals who you are politically against and you arrest them without any evidence, and then no bail is granted because there is a suspicion that they have committed the crime, where do we go from there? And if you add 120B, which is what is conspiracy, he's not directly involved in any offense, you will say 120B, conspiracy. Now you can't prove conspiracy. There is no basis for proving conspiracy, but you'll keep him behind bars. So the issue is, how do you formulate a legal framework within which an arrest must take place? The hierarchy of officers is not going to make a difference, and I agree with you. We need a framework through which arrest can only happen if prima facie it is established that I have committed the offense. Well, unless you're able to show that to the magistrate, there should be no arrest. I think that's very important.
So the power should be taken away from the echelons of the police.
Yes.